When someone is charged with a DUI here in Illinois, they've got two big problems that they need to deal with. The first one is obvious. They're charged with the DUI. That's a criminal offense, and there will be an outcome to that case. We've talked about, in another video, a number of different ways to beat that DUI. Now, the second problem that they need to deal with is their license is probably going to get suspended shortly after that DUI. And that's what we're talking about today. What are the ways that we, as DUI lawyers, can stop or overturn that suspension that occurs after a DUI? Let's get into that. So, Kelly, when we talk about all the different ways of stopping or overturning, really the word is rescinding a suspension that occurs after a DUI, there's kind of two broad categories, at least in my mind. One of them is like on a technicality. We're pretty good at that, right?
Yeah, we love those.
We love those. If you know the law and you know how to work the system, there are some technical ways to overturn that suspension. There's also the substantive ways, right? And what I mean by that is the things that the officer says happened didn't really happen, right? Like the things that occurred on that street when you were out driving the car or on the side of the road are not really what they seem, and that's a matter of fact that gets argued in court. It's fair to categorize them those two ways?
Very fair. I think that's a good way to think about it.
Let's talk about the technicalities a little bit. There's a bunch, and I don't know that we're going to cover them all in this video, but what are some ones that come to mind?
One of the technicalities that comes to mind is what they call due process. So the state's attorney has to give you a hearing on this issue within a certain amount of time. If they can't give you that hearing because either they can't get their officer into court on time or they haven't given you all the evidence that's necessary to have this hearing, then sometimes you can win just because of that.
Yep. So I'm in court and I say, my client's about to get suspended or was just recently suspended. I want to have a hearing on the substance. But I can't. I can't even do that on behalf of my client because you, prosecutor, have not given me videos or the officer's not here to be part of this hearing, right? So there's some problem. The prosecutor has not sort of fulfilled what they need to do. Therefore, we're prejudiced by not being able to have a hearing. Therefore, the only solution is to eliminate that suspension overall.
Correct.
As a shorthand way of describing it. So that covered a couple different things though, right? Officer not being there when he's supposed to, videos, police reports, right? Like evidence documentation not being there when it's supposed to.
Yeah, I mean, another technical way that you can win a suspension is through the notice of summary suspension. So when you get arrested for a DUI, you're brought back to the police department. They are going to let you know what's going to happen with your license. If you provide your blood alcohol content or not, and then how long you're going to be suspended for. They need to give you a document, which is called a notice of summary suspension, thereafter. And that is what's called a pleading, which is basically like a formal court document. It has to follow certain requirements. If the officer messes up that document, sometimes we can argue that and get the suspension back.
Yeah, very technical, right? It's not like this wasn't him or this wasn't our client or he wasn't driving. No, it's like this officer filled this out wrong, and by law, he's required to fill it out right.
Correct. One thing is that it has to be verified. So they have to sign it. That could be one way. Another way is just messing up the information within the document. Like sometimes we've seen where the officer put the client's date of birth instead of the date that the test was either provided or refused. Another way is this happens a lot. Like say somebody's taken to the hospital. The officer will put on the report that they gave it to the person that very day, but that can't be true because they didn't know the blood alcohol content until they got the lab back.
Right.
So in that situation, they're supposed to mail it to the individual, and then the suspension should start 46 days from the date that they mail it. If they say that they gave it on that day, our clients are prejudiced because they got suspended way sooner than they should have. So that's a super technical way that we win sometimes.
Very technical, right. Just essentially the wrong boxes are being checked,
exactly.
Right?
But it matters.
It totally matters. Yeah, I mean, and the only way you really know this stuff is by doing a a lot of cases and seeing a lot of different scenarios because truthfully, officers do mess up this paperwork all the time. I mean, think about it. It's 4 a.m., right? There's a car crash that they're responding to. They're going to the hospital back and forth. There's 2 or 3 people sometimes being arrested. Like, there's crazy scenarios, right? And they check a box wrong. You can bet that we're going to hold them accountable to that, obviously, if it affects our client.
Yeah, we also see, too, that, like, they'll use the breath result from what they did on the street, which you can't do. Or they'll ask the doctor at the hospital, because if you go to a hospital, they're going to take your blood, and then they'll be like, hey, doc, what was his BAC? And they'll tell them, and then they'll write that on the document. Can't do that
That's
either.
a no-no.
Yeah.
All right, so Kelly, now let's jump over to the substantive side of arguing in court why our client's license shouldn't be suspended. What's one of the more common ways we do that?
I would say the most common way regarding your suspension is arguing that the officer had no reasonable grounds to believe that you were driving under the influence of alcohol. One thing I do want to touch on, and again, this is kind of technical, but these hearings are civil in nature. So the burden of proof for a criminal aspect and then what we're talking about is different, and it's lower, not in favor of drivers. It's by a preponderance of the evidence.
Yep.
So the judge basically just has to believe that it's more likely than not, or if you want to think about it as a percentage, like 51% likely that the officer did have reasonable grounds to believe that they were under the influence of alcohol. So although I think that this is probably the basis we like the best because we like to litigate, we like to be on trial and get to the merits of the case, this is also the most difficult way for us to win one of these hearings. The other kind of weird thing about this issue is that we, as defense attorneys, have the burden of proving to the judge. So it's actually our petition, our burden. We go first. We can decide if we want to call the police officer or if we want to call our client to try to prove that the officer did not have reasonable grounds to believe that the client was under the influence of alcohol. The best way to do this is what we're always talking about in our YouTube videos. Don't provide the police with those reasonable grounds. So the best way is not making any admissions, not doing the field sobriety test, and not blowing on the street. That way you're not giving the police any reasonable grounds to believe that you're under the influence.
So yeah, there's really 2 thresholds that an officer sort of needs to meet and 2 things that we can attack here, substantively. The first one is like, why did the officer stop our client in the first place? Like, say, for example, he says, well, I stopped this vehicle because they didn't use their turn signal. And then we get this video and we're like, yeah, he did use the turn signal. We can see that. Well, then everything that occurs after that should be thrown out. At least that's our argument, right? Like the officer never should have stopped him in the first place. The second one is even though it was a good stop and this officer is at the window and they're talking, the officer never had a legal basis to get him out of the car, have him do all these tests on the side of the road, and then put him in handcuffs for DUI. In other words, the DUI arrest never even should have occurred. And if you can successfully win that argument, well, then obviously the suspension that comes from the DUI arrest shouldn't have occurred. At least, again, that's our argument. And then you got to get the judge to agree with you. What are some other substantive things?
Another substantive way you can win the suspension of somebody's driving privileges is through the warning to motorists. So this is a situation where somebody's gotten stopped, they've gotten arrested and charged with the DUI, and they're brought back to the station. Before this person is going to provide a sample to prove what their blood alcohol content is, they need to be read this document. It's like an 8x10 piece of paper, small print. There's a lot of technicalities in there. And the officer literally has to read it verbatim. And it informs the suspect what is going to happen if they do provide their blood alcohol content or do not provide their blood alcohol content as it relates to their license getting suspended. If the officer doesn't read it verbatim, that can be a basis. If they don't read it at all, obviously that can be a basis. We've also won where the officer did read it correctly, but then afterwards tried to explain what they just read and did so inaccurately.
Yep.
So those are always fun. But with that, the best way to show that is through an officer's body-worn camera. Unfortunately, every department is not equipped with a body-worn camera, and many booking videos do not have sound.
Yep.
So some people are kind of left in the lurch there a little bit with that one.
Really important one. I mean, again, I'm just going to summarize it. By law, they have to do some things. They have to read you this stuff so you can be informed about the decision you make. That's not true in every sort of police interaction, but when it comes to suspending somebody's license for a DUI, that is required. And you'd be shocked how many times an officer screws it up or cuts corners. Another one I can think of is private property. You want to talk a little bit about that?
Yes. So earlier when I said that we have to prove that the officer had no reasonable grounds to believe that the client was driving under the influence of alcohol, there's actually a second part to that, and that's on a public highway. So sometimes you can get your license back if you were on private property.
And I mean, we've seen it before. I can think of a case not that long ago where somebody pulls up to the gas station and they park their car. They go inside. They buy a couple things, including alcohol in the gas station. They go back to their car, and they're in their car for an hour. Eventually, the people at the gas station are like, I'm going to call the cops. I don't know why these people have been sitting in their car for an hour, right? Cops come, and they're like, wait, you're drunk. Did they show up originally drunk, or did they just consume the alcohol? I don't know, right? Those are things we can argue over. So believe it or not, that happens more than you would realize. Or things like that happen more than you may think. And so the point here is that is like a real question of what occurred, right? An officer sees it one way, we see it another way. And so should that person's driver's license be suspended? That's going to be up to the judge to decide if we have that hearing.
Yeah, we basically just have to put forth some proof that, it was on private property and that it's possible that they could have gotten intoxicated on that private property. Obviously, another good example is like somebody's house. You could be drinking like in the driveway. That's not going to get you out of a DUI, but it could get you out of the suspension.
So that's an important distinction because the on a public highway wording applies to the suspension of the license, but it does not apply to the DUI?
Correct.
Interesting to know. And that's specific to Illinois. Other states might be different, but that's how it works here in Illinois. You can get a DUI in your own driveway. A shocker. I mean, it really is. Yeah. It's wild.
And then another kind of really interesting issue is sometimes you can go to court, you've gotten all of the evidence, and the officer's not there. And you get the case called and you're like, yes, the officer's not here. We're going to win on the technicality. And then the state tells you, oh, no, we're going to answer ready on paper.
Right. On paper.
Yeah.
And
you're an expert at that.
Yeah. And so what that is there's no officer to testify, but they can still introduce his report, this officer's report of what occurred that night. And so really it's you and your client versus a report versus when normally it should be you and your client versus the officer's word, right? And so obviously you're at an advantage when you're going against a piece of paper and a report as opposed to an officer. So if we get in those situations, or we can, sometimes you just walk into those situations, obviously you want a lawyer that's ready to go on that and take advantage of that sort of fortunate situation.
Yeah, that's why it's really important, again, not to provide that evidence against you on the street, especially blowing on the street. Because if the judge sees in that report, okay, you did the fields, whatever, you admitted to drinking, that's fine, but then you blew a .16 on the street, that's kind of blowing our argument out of the water.
So, guys, have you noticed that there's a lot to this? I mean, literally, we're talking about just one half of a DUI. We're not even talking about the criminal charge. We're talking about the driver's license suspension. And we listed, a dozen different ways to beat that. And there's actually more, too. So the take home here is, I don't care if you hire us or not. There's plenty of good DUI lawyers. But hire a DUI lawyer if you are charged with a DUI. It really grinds our gears and we talk to people who they hired their immigration lawyer or their family law lawyer, the next guy off the street to handle a DUI. It is an extremely complex case. There is a ton of laws about DUIs because there's a ton of DUI cases and those cases produce new law. So my word to the wise here is hire somebody who can talk like we talk. Hire somebody who can handle cases like we do, even if it's not us. I hope you learned a little bit about your case, and good luck on it.